Afternoon, everyone. I'm Steve Springer, and I'm a partner with Stone Rudolph and Henry CPAs, and we welcome you to our webinar this afternoon. We have a real treat today. We have a guest speaker, Chris Johnson. Chris is an attorney with Takacs McGinnis Elder Care Law Firm. And Chris, we welcome you. This is the first time we've done a session together, and so we're excited about hearing from you and the information that you're going to be providing to us. Just a little bit about Chris. I won't go through his whole bio. It's very impressive, but Chris has a little over 20 years of combined experience as an attorney and also in the military. You are a U.S. Marine Corps, right?
Yes, sir.
And a graduate of the Naval Academy and then the College of William and Mary. So very impressive resume there. And so, Chris, I'm not going to steal much more of your time. I just want to say welcome. It's great to have you with us today, and everyone who's listening in and watching. Thank you for taking part in today's session. We try to do these seminars, webinars now at least once a month, and so we invite you to pay close attention to our upcoming schedule of events that we have, and we'll be sending out information as well. But be sure and check our website. There's always updated information there about some of the sessions that we have going. So Chris, welcome. I'm just going to turn it over to you to get started. Throughout the program, I may ask you a few questions or interject a comment or two, but I look forward to hearing what you have to tell us today.
That sounds fantastic, Steve. Thank you so much for having us here. It's a real honor to be a part of this. We love sharing this information with the community. The old adage that a high tide raises all boats, and we want to get the word out there regarding these estate planning and elder law issues so people know what they don't know, so they can start taking the right steps in order to make sure that they're protecting themselves and protecting their children down the road. So let me bring up and share the screen right now and get the PowerPoint on there. Hopefully this goes very smoothly. Is it looking good, Steve?
Looks great.
All right, fantastic. Well, let me get started. As Steve said, my name is Chris Johnson. I'm an attorney. I've been an attorney for the last 14 years. I've done about half of that in the civilian world, and the half before that, I was a Marine judge advocate. I served in the Marine Corps since 1999 and loved every minute of it. One of the great things about elder law is that you deal a lot with veterans. We have a big, robust veteran community here in Middle Tennessee. Having worn their boots and walked a few miles in their boots, I know what it's like, and I want to make sure we're helping them and frankly helping everybody, because it is getting to be more and more of a Byzantine process, the process of getting older and how you deal with all these outside entities, the Veterans Affairs Administration, dealing with kin care. And we want to make sure that people are squared away even with the most basic documents. So with that, let's start. And what I'm going to do is I want to talk about this is everything you ever needed to know about elder law. And so we're going to hit the wave tops on a lot of topics. It's not going to make everyone an expert today on each issue, but it will make you a good issue spotter. So you know, hey, you can look at what you have, your documents, your kind of critical estate planning infrastructure and think, do I have any holes in there? Do I need to consult with an attorney and start looking at planning for the future? So without further ado, slide one, all I need is a will, right? And I promise I'm not going to sit and read from the slides. But when people think of their estate plan, this is the foundational document that people think of. They think, I got a will, I'm taken care of. And to some extent, it is a foundational document, but it is certainly not the only document you need. And I like to emphasize the estate planning documents that take care of you before you pass, to me, are much more vitally important than the ones after you pass, because they affect your lifetime. And a will, all a will is really doing is taking what are called your probatable assets, that's titleable assets that are not otherwise designated at your passing, and it does the orderly transfer from you to your heirs or whoever your designees are in the will. And although that is very good to have and certainly a foundational document, it is by far and away not the only document you need. And with a will come lots of issues that I'm going to get to as we move along here. So talking about it not being the most important estate planning document, revocable living trust, you see there on the screen. A revocable living trust is a great tool because a trust Trust document is essentially a contract, and what you are doing is you are placing assets into the trust to be managed by another person, and that other person is called the trustee, and you're handing those assets to the trustee to be managed for another person's benefit. And what that does is, under the law, we kind of refer to that as the dead hand controlling, because after you pass away, those assets can still be managed without full distributions. And I think we all can reflect back on when we were 18, 19, 20, although under the law we're full-fledged adults and certainly able to own property and enter into contracts, we might not have been the best decision makers at that time. And so if you have children that are kind of in that young adult stage, they're fully adults, they're no longer minors, but you don't want them to get a lump sum. A trust is a much better vehicle to make sure that those assets are managed until they kind of reach that maturity, in order to be able to appropriately manage and not squander the hard-earned life savings that you have set aside for them through your estate planning. So the revocable living trust lets you put all sorts of caveats on it, all sorts of rules on it, can be used for education, almost anything you can think of under the sun. A revocable living trust will not protect your assets from TennCare, from the nursing home. And that is a crucial mistake, because people will oftentimes say, well, it's no big deal, I put it in a trust, or this attorney put everything in a trust, he said I'm good. You need a trust is like a tool in a toolkit, and you want to bring the right tool to the right job. For anyone that's done any, handy repair around the house, you know how frustrating it is when you're looking for the appropriate tool and you don't have it, and you try and use the wrong tool, and you generally end up screwing up the job or hurting yourself. And it's a great analogy with estate planning, because it's the exact same way. So wills take care of all of my money? Not really. As I talked to you earlier, they deal with your probatable assets. With a bank account, you can do what's called a beneficiary designation, so that at your passing, I can beneficiary designate my account to my wife or to my son. And what that does is that asset now passes outside of probate, which is a nice thing to do. But you can't put the rules on it. And there are other negatives that come along with just directly transferring that money. Maybe we don't want to transfer the money in that respect, but that will keep it a non-probate asset. Using a trust is another way. If I deed my home into my revocable living trust and then I pass away, now the trust owns the home, and then the trust will manage the home in the rules that I have laid out. Another way to take a probatable asset and turn it into a non-probatable asset. If you have stocks, you have transfer on death beneficiary designations, another great tool. Oftentimes we'll use these tools in conjunction with one another. So if we want everything to go to the trust, we will take those bank accounts and we will have the client's beneficiary designate the trust. So at their passing, those accounts are payable to the trust. The trustee brings the paperwork to the bank and gets those funds transferred into an account in the name of the trust, and then starts executing the duties as the trustee. Now, here's a great misconception, the formal reading of the will. And Steve was sharing with me a real humorous story yesterday about a time he served as executor. This is a great misconception, because we still see it. It cracks me up. We still see it on TV. You'll still see it in the movies, the reading of the will, the very formal and solemn affair where everyone gathers in the attorney's office and everyone's kind of dressed in black. No one does that anymore, I should say, you never say never. It is exceedingly rare and highly unnecessary. It harkens back to a time long ago where two things were true. A, the attorneys kept all the original wills, and that was usually because the attorney had a safe. Most people lived in all wood homes. I mean, we're talking, decades, 100 years ago or so. And that was about one of the few places to keep your will safe. And the second thing was the attorney, we take for granted the literacy rates we have in this country, but 100 years ago, it wasn't quite like that. And so the reading of the will served a very perfunctory function. And that was, the attorney was one of the people in town who knew how to read and write and could therefore read the will, and everyone could hear what it is. It is an archaic event at this point. Does it still happen? I'm sure every once in a while an attorney does it, but it's exceedingly rare. And to manage expectations, do not expect a reading of the will. At most, you'll probably receive a copy of the will or information from the executor or personal representative informing you that you're in heir and what to expect and a little bit of how the process will go along. So another misconception.
I have a question for you, Chris.
Go ahead, Steve, jump in.
Wouldn't you say that most of the time it's a great idea for, let's say, parents to go ahead and communicate to their family members, their heirs, how things are going to play out once they have deceased? You know, discovering what's in the will really shouldn't be a great surprise to anyone, should it? If planning is done properly?
No, if planning is done properly, and that's a great point. Communication, if you want your wishes to be honored, communicating those wishes to the people who are going to have that control and have that authority to make those decisions is vitally important and a hallmark of any good planning. Now, I always recommend it, and I recommend it with one singular caveat, and that is, I also know it's not always possible in every familial situation. We have blended families. We have families where maybe family relations are a little bit strained. And I will get every once in a while, Chris, we would rather not share some of the details. And what I will say is, that's fine. You don't have to share distributions or who's getting what, but you need to share that A, you have a will or a trust, B, where it is, and that's a big one that people make a mistake. And please, whatever you do, do not put your will or your trust in a safety deposit box, because often the authority to get in that box, if you keep all your documents together, will be contained in the box, and it'll be quite the conundrum for your heirs. Make sure they know where it is, and then also make sure the key players know. If you're tapping someone as executor, as personal representative, or as trustee, that's not a great surprise. I often joke with clients, you're not giving honorariums, you're not giving titles, you're giving these people a job, and they should know about it up front. And if they're unwilling or they think they're unable to do it, they should have the opportunity to share that with you so that you can pick someone who will be able to honor your wishes. But yes, the communication is a vital, vital piece. But I'm his wife, or I'm his husband, or her husband. Spouses do not have any inherent legal authority to make legal decisions on behalf of their spouse. This is the whole reason why we have powers of attorney. And the nice way I like to describe powers of attorney is, when most of us are familiar with Microsoft Word or Outlook or these software programs that we have, when we turn 18 years old, we are imbued with a whole host of legal rights that we can do we can sign contracts, we can own property, we can sue people, we can get sued, all of these things. And what we're doing is we're walking around with all these rights. Well, if you want someone to be able to act on your behalf, you need to designate that in writing via a power of attorney instrument. And what that does is, it's like highlighting text on Microsoft Word and hitting the copy and then paste function. And what you're doing is you are copying your rights and you are pasting them on another person. And that's vitally important. You're going to hear this word again. It's called a fiduciary obligation, which means they have an obligation to do what is in your best interest should you be incapacitated. And so obviously they can't self-deal or make gifts to their friends. It is their job to act as if they were you, if and when that needs to happen. And so we have a durable general power of attorney and we have a healthcare power of attorney. That decision-making process isn't conveyed simply through the bonds of matrimony. It is conveyed in a legal document called a power of attorney. So who is the principal? A principal is the person conveying the legal authority. So if I wish to give my wife power of attorney, as I have done, I set up the instrument, I am the principal, and my wife is the attorney in fact. She is the person who can act on my behalf. Must a principal be competent to sign a POA? Yes, absolutely. You cannot put a power of attorney under the nose of someone who doesn't know what they're signing. That is highly inappropriate. And just tell them, just sign here. They need to have the cognition to know what's going on. And hey, I understand the document I'm signing. I know it's going to help me take care of my affairs. There are 3 things you cannot do with a general power of attorney. These are my favorite things. Because it is the political season, it's always fun to talk about voting. You cannot vote for someone else on their behalf. You can't take the power of attorney, go to the polls and say, I know who they want to vote for. That's something you got to do in person. Number two, you cannot execute a will on behalf of that person using a power of attorney. Again, the opportunity for mischief is just way too great. So the law says, hey, we're not going to allow you to execute a will. And number three, and probably my favorite, is you cannot stand at the altar in their place and marry them off to someone else. Another event in life that you're going to have to show up for. Personally, everyone generally gets a kick out of those, so I always like sharing. There are limitations on your power of attorney. What makes it durable? A durable general power of attorney is effective upon your signature and stays in effect after your incapacity, because a power of attorney is revocable. And so at any time, if you are uncomfortable with who you've conveyed the authority to or how much authority you have conveyed, you can always revoke it. In the state of Tennessee, you can revoke it verbally or in writing. Obviously, as an attorney, I'm always going to recommend that you do it in writing and provide notice to your financial institutions, financial planner, anyone where some significant damage could be done, because obviously you're revoking it for a reason. But it survives. They want to make sure that you have specifically contemplated it surviving your incapacity, because what important thing do you lose when you become incompetent? You have lost the ability to revoke it because you're incompetent. And so they want to make sure. Now, most people, that's why we want to have a power of attorney. While I'm, have all my faculties, I'm fine. I don't really need it. I want to make sure that's done. But the law wants to make sure that you have contemplated that and that you are comfortable with that decision. And that is what makes it durable. Another type of power of attorney is called a springing power of attorney. And that's one that is not in effect while you are competent, but springs forth once you have become declared incompetent or incapacitated. And so when you hear the term springing power of attorney, just think of a power of attorney that is not effective until something happens to you, and then it springs forth. So what does the attorney in fact do? So I kind of went over the don'ts. If you get into a car accident, they can hire an attorney, and if that's why you're incapacitated, and they can start a lawsuit against the person who injured you. They can get with your CPA and make sure your taxes are filed. They can take care of banking transactions. They can take care of real estate transactions. If you execute a real estate transaction with a power of attorney, expect that the real estate agent is going to demand, and the title insurance company will demand, that the power of attorney be recorded along with the deeds. Why it's also important that your power of attorney has a prepared by section on the top of it, so it shows who it was prepared by, what the law firm was. Very important thing. But what that person does is they step into your shoes legally. And now you heard me mention the copy and paste. I'm going to talk a little bit later in this presentation about a different version of transferring your rights that is more akin to a cut and paste. And you'll hear me reference why a power of attorney is such a better decision. So advanced directives, healthcare power of attorney side. This is your medical decision making. So while you're competent, while you're in the doctor's office and can talk to the doctor, obviously you're in charge of your healthcare decisions. Should you not be able to do that, should you be in a vegetative or comatose state or otherwise incapacitated, we need someone to step into those shoes. Now, there's different ways you can relay your wishes. The one that we recommend the most is via a power of attorney. That is appointing another human being to go there and have your legal rights, be able to talk to the doctor face to face, request your medical records, demand a second opinion if they believe that a second opinion is necessary, and truly ensure that your wishes are carried out. Why I think it's important is because I'm going to go on to a living will here in just a second. A living will is a piece of paper that kind of has some yes, no questions or some guidance, no extraordinary measures, no feeding tube, no artificial resuscitation. And it goes through all of those things, except those are very simplistic questions, and your medical events are typically often very complex events. And so you have this, what I call, have a hatchet, and you're trying to execute something that needs a scalpel. And so if you appoint a person, that person can question the doctors, that person can demand a second opinion, that whole list of things I went through. Whereas a living will, what that's doing is just laying out kind of yes, no, yes, no. Now, the doctor can use that, and it's wholly legal and wholly appropriate, and especially for a growing segment of our society that we refer to as unsupported elders. And this are elders that don't have any close family members that they can trust as power of attorney, or they just don't have any close friends that they can trust to make these decisions for them. Then yes, a living will is a great thing because it's better than nothing. But if you ask me, a living will or a healthcare power of attorney, I want an individual in there because that individual can advocate for me as well. That individual can say, let's run more testing. That individual can evaluate the doctor. Is this the doctor that I think, graduated first in their class at Vanderbilt, or is this a doctor that maybe didn't do so well? And I'm not so sure, because doctors are wonderful and amazing people. I certainly hold them in the highest regard, but does not make them infallible. And so having someone that can question and advocate for you is vitally important. The last one on there, a physician orders for scope of treatment. This is between you and your physician, often like right before a surgery or something like that, where they just want to go through, hey, if this happens or this happens, what do you want? And they run through that with you rather quickly. That's if you show up because a living will or a healthcare power of attorney, you're often going to your attorney for. It's an easy thing that gets put off. So if you show up at the hospital and need significant treatment, they will often want you to fill out a post there on the spot so they at least have some guidance. And that's a good thing. If you don't have any other planning documents, filling out a post right there is great. But if you're going into a hospital and you have a healthcare power of attorney, bring that document, bring a copy of that document, provide it to them, say, I have a healthcare power of attorney, this is who it is, here is how you contact them. They will know what decisions I want to have made.
Chris, your comments made me think about something. I have a 25-year-old single daughter, and it just occurred to me, boy, she's at the age of majority. If she were to become ill or have an accident or something, she would need these same documents, or really put it the other way around. I would probably need those documents to be able to act on her behalf, right?
Absolutely. And I can't emphasize this enough. People think of estate planning as something I'm going to do later on down the road. And I try and emphasize everyone needs these documents, just the fundamental underpinnings documents: revocable living trust, pour over will, healthcare power of attorney, durable general power of attorney. Those 4 documents, if you have those 4 executed, your proverbial ducks are in a row. Now, as we get older, there is some more planning and some more technical planning, more complex planning that we may want to do and layer onto that to put you in a more advantageous position. But it doesn't matter if you're 18, if you're 25, like your daughter is, Steve. When you hit the age of majority, when you are no longer a minor, you want to have these documents. These powers of attorney, they take care of you while you're alive. And the last thing you want people doing is scrambling or guessing in order to have your wishes honored. And it's a scary thing that we don't often think about, but tomorrow is never promised, and you need to have these documents there. And as you said earlier, Steve, you need to make sure that people know about them, because it doesn't do any good if you execute it and don't tell anyone about it. Well, you might as well not have executed it. This is a great quote. I have an advance directive, not because I have a serious illness, but because I have a family. And that's really what you're doing, is you're taking care of your loved ones because you're helping them take care of you. And you're making their jobs and their lives easier should you suffer a catastrophic event. So you heard me allude to earlier, that was the power of attorney, is what I affectionately refer to as the copy and paste of your legal rights. Well, there's another version. It's called the cut and paste. This is what happens if you don't have a power of attorney, and it's called a conservatorship. So if something happened to me and I didn't have a power of attorney designated, my wife would have to petition the court and file a petition for a conservancy and try and be named conservator over me. Now, I would be at that point called the ward. And what happens is they open up the conservatorship and they're going to immediately assign me an attorney. My funds are going to pay for that attorney, even though I'm incapacitated, because I am what's referred to in the court at that point as the potential ward. And that attorney is then going to meet with physicians and have them write reports, look at me and deem me, am I fully incapacitated? Am I fully incompetent or not? And then they're going to give those reports to the court. They're going to give those reports to the petitioner. Also, excuse me, other interested parties are going to be noticed, and they may come and challenge. And this is truly the worst kind of fight. And so it often happens with elderly parents. You have adult children, and what happens is something happens to one of the parents. We don't have powers of attorney in place, and the children disagree on the right course of action. And so one of them files for conservatorship, the other one challenges, and now you have what I refer to as the worst kind of custody fight ever. You have a custody fight over mom or dad, and it's worse than a custody fight over a child because of this. With the child, we're truly just talking about custody. But with the custody of mom or dad, we're also talking about generally control of the finances. Now, sometimes the court will split it, but most times they do not. And I've been a part of a contested conservatorship. It was between a brother and a sister, and it was just awful. It's awful, the allegations that are raised, and the rifts that it causes in the families are not easily healed, if ever healed. And the last thing you want as a parent are your children or one of your children and your spouse, especially in a blended family, fighting over what you want, when at the end of the day, you could have filled out and had a simple power of attorney executed, and then it's clearly laid out what your wishes are. Because when someone finally is granted conservatorship over the ward, they are going to be the decision maker. They are going to be the ones who can have the power of attorney, except unlike the power of attorney, they're going to have the authority much like the power of attorney. However, the power of attorney, you still retain your rights. You have pasted them onto another person. With the conservatorship, your rights are stripped away, cut, and pasted on another individual. And courts are very reluctant to do that. They maintain a high bar. Our individual freedoms are very much a hallmark of our society. They don't want to do that unless they absolutely have to. But conservatorships, the last piece that I want to hit is they are exceedingly, or can be exceedingly expensive. That money is going to come out of the ward's estate. And that's another frustrating process. They can cost tens of thousands of dollars if they're contested. And truly that's wasted money compared to just getting a power of attorney executed. So have the conversations. You don't want to just rely on, well, my family will do the right thing. If they don't have the legal authority, they won't be able to do the right thing. And your life isn't really a democracy. You are the one time where you're kind of the dictator of your life. You get to say what you want and who's in charge. And you don't want it to be, especially at the worst moment, because remember, if people are fighting about this, something has happened to you. You want them doing what we all want them doing. We want them worried about you, spending time with you, taking care of you, not in court fighting over who's in charge and what decisions are going to be made. Absence of a plan is a terrible, terrible burden on a family. Now, how long-term care gets paid. What I'm about to walk you through in the next slide is called the Elder Care Continuum. It is probably the slide that I will spend the most time on. It is a vitally important slide because what it does is it really shows that there is a science behind how we age and how it affects us. Now, there's going to be a timeline. Not all of us travel along this timeline at the same rate. Some of us go very quickly along the time frame. Some of us have a very slow, methodical march from one end to another. All of that affects how you get paid. And keep in your mind this overarching, or how your care gets paid. Keep in mind this overarching principle. The healthier you are, the less your care costs are, and the more likely you are to retain the assets that you've worked so hard for over a lifetime. And that is an overarching principle of what we do. On our intake worksheet, before I ask about assets, before I ask about the children, we ask, how's your health? Because that is going to drive the planning train. We want to make sure that your care needs are met. And again, think about your care needs on a little bit as an investment theory. A little bit of money now will pay off larger dividends in the long run. But if you fail to make prudent investments in your health, in your care needs now, that will hurt you, and you are setting up real obstacles for yourself down the road. So here is the elder care continuum. So that first line is what we refer to as the functionality curve. And what I want to emphasize is in the elder law world, we measure functionality through the activities of daily living. Can I bathe myself? Can I dress myself? Can I toilet myself? Can I cook and prepare and feed my own meals and feed myself? And can I safely ambulate? Can I safely move about in my environment without being a fall risk? Now, most of us on this continuum curve at that no functional limits, most of us stay there for the vast majority of our life. We turn 18, we're a full-fledged adult, and we get to 40, 50, 60, yeah, we might have some aches and pains, we might not be running marathons, but we're there. We have no real functional limits. That's a great thing, and that's how we all hope to live, but there is a downside to that, and the downside to that is critical. When you do something a certain way over the course of decades, it's hard to accept that things have changed. And so the first example I'm going to use is a very silly one, I promise you. But I always say, if you can recognize the small ones, you'll catch the big ones. So on that functionality curve, I have moved just a little off the no functional limits. And where I'm at is 2 years ago, I got these. So I have glasses now, something I didn't have for the first 40 years of my life. And I finally broke down when I was in a restaurant. It was a dark restaurant. It had a menu with real small print, and I could not read the menu. And it was frustrating, embarrassing. My wife, gave me the business as appropriate. But I have moved down that care curve just a little bit, that functionality curve. I need my glasses now, and I need to accept that. If you pay a kid to mow your lawn, if you pay a service to clean your gutters because you don't want to get on a ladder, if you have someone clean the house and you don't want to dust the ceiling fans and whatnot, all those things you've moved just a little bit. Now, are they a big deal? No. In our world, are we overly concerned about those? No. But I use those as an example so you will catch the big ones. And two of my favorite stories on catching the big ones and how easily they're missed. Because you would think, can I dress myself? That, Chris, I'll know if I can dress myself or not. I met with a client and we were talking about whether or not mom and dad could dress themselves. And they were like, oh yeah, mom and dad are fine. They get up in the morning, they put on their pants, put on their shirt. They can't put on their shoes and socks. And, but they said, no big deal. They can dress themselves. And I said, well, wait, they can't, literally they cannot put on their shoes and socks. And they said, well, yeah, but, we come help them out with that. And I said, well, then they're not dressed. And of course they were like, well, no, of course they're dressed. And I said, no, they're not. And I asked them, I go, where can they go? And they looked at me and I said, where? I go, I'll give you that they can go to the beach. Where else can they go in our society without shoes and socks on? They can't go to their grandkids' school. They can't go to a restaurant. They can't go to a store. They can't go to church. Having shoes and socks is a vital element of being able to dress yourself. And they had never thought about it like that. And it kind of dawned on them, oh, I see that. That's actually a bigger issue than we thought about it. They did not have the ability to complete that function. And then the other one, and one of my all-time favorites, because as an attorney, I think I grew in leaps and bounds the day I met with these clients. We had a mom living at home alone. And I was going through the activities of daily living, and we got to, can she cook and prepare her own meals? And they, oh yeah, absolutely. She loves to cook. She's amazing. We've only called the fire department 3 times this month. And, I kind of chuckled and I was waiting for the punchline. And I was like, well, there's gotta be a funny story behind this. And they just looked at me and I then felt very dumb. I felt like I was insulting them by chuckling. And so I said, well, I guess I don't understand. And they started to explain to me, well, grease fire, curtains caught on fire, something burned in the oven. And I said, well, that's not really normal. And they said, well, yeah, it is. That happens to everybody. And we kind of hit this impasse. And I was beating my head against the wall because I knew that isn't normal. I know that's not normal. And I'm trying to convey that. And I realized I'm making no headway. So I stopped. And I did one of the most important things an attorney can do. I listened. And I said, I had, I believe it was the son, it's been a long time now, and the son's wife. I said, tell me about your guys' day. I go, I'm missing something. And so they were my age. They had children who were in school, and they said, well, we get up in the morning, get our kids up, fed, off to school. They were both professionals. So on their way to work, they'd stop by moms or mother-in-laws, get her dressed, get her up ready for the day, go to work, do their full jobs, come home, get the kids from school to their after school activities, get them home, get them fed, get them working on homework, go over to mom's, get her fed, get her squared away for bed, and then they'd come home and they'd have about 5 minutes to themselves and then they'd collapse. And I said, well, how long have you been doing that? And they said, around about 3 years now. They didn't know anything else. It's where the term caregiver burnout comes from. Their social circle, which, you know, had just been their whole world, had gone down to just those events I went over, and they'd gone over it for 3 years. So to them, what they were going through was perfectly normal because that was their world. And to them, that's very normal. And it's a hard thing to fight through. And so you would think that that activity of daily living would be obvious that they can't do it. It's not when you're stuck in that cycle. They needed help. They needed someone to come in and give them some time off and help care for mom so that they could just rest and recover from the work, because the work they had been putting in was exceedingly taxing. And you could almost see the proverbial light bulb go off in their head, and they got it. And at that moment, they got it. Once the client gets it, there's a lot of good that you can do. And so I emphasize those because the next thing we want to do, the next line, we want to make sure that you are receiving the care you need. And so that functionality curve at the top defines and lays out, this is where I need care. This is how much care that I need. And then the second line is your care is almost always associated with where you're living. And so that second line is, this is where I'm getting the care. All of us want to be on the left side, living at home, home sweet home as we refer to it as. And I want everyone to live at home as well. But what I always tell clients is, it isn't as important where you are living. What is important is that your care needs are being met. Because if you are towards the right on the functionality line, but back on the left and still living at home, what's happening is the care you're being provided is lagging behind your care needs. And that creates a danger zone, because when your care needs are not being met, that's when you have an increased propensity for a fall, other type of catastrophic medical event. And if you fall and break your hip, you are fast forwarding all the way to the right of that functionality line. And what stinks is that means you are going to fast forward to the nursing facility. And what I tell people is, if I fall and break my hip, it'll stink. I'm going to have surgery. I'm going to go home for a week or two. I'll have a walker, and then I'll have a cane, and I probably won't run marathons anymore. But I also will get back to about 85, maybe if I'm lucky, 95% of what I once was. But if I'm 65, if I'm 75, I'm 85, that's not going to happen. Now that surgery is a major event, I'm probably going to be in an ICU after the surgery, at least for a short time, to make sure I'm okay. Then I'm probably most likely going to a skilled nursing facility, and I'm trying to rehabilitate my way back down the functionality curve. And if you rehabilitate yourself 50, 60, 70%, you've done real well. You're probably getting to the limits of where you can get pre-injury. And what happens is that's going to drive where it's safe for you to live. And for those that want to live at home sweet home, you need to think about taking the appropriate steps. Are the stairs dangerous for you? Install a chairlift. And I know that's a couple $1,000s, but a couple $1,000s is half the cost of 1 month of a skilled nursing facility. It is a small price to pay. If you have a good, robust nest egg in the bank, spend that small amount of money. Change your bathtub with a walk-in tub if you don't feel safe. Put rails around the tub, put rails around the toilet, or downsize if you want. Hey, maybe it's time we move in a townhome or a condo that's 1 floor and no stairs. Those things make a big, big difference. And so on the home sweet home, the care being provided curve, you have living at home, then you have at home with assistance, and that's in-home caregivers. Retirement, so independent living facility, then you have assisted living facility. In between there, although it's not on there, you have memory care, which is kind of a subset of the assisted living facility and a little bit of the nursing home, depending on where you are physically. And then we have the skilled nursing facility at the end. And each one of those things has an associated cost. And so on the cost curve, which is curve 3 of the continuum, let me go over what these things cost. At least in our area in Middle Tennessee, these are good rules of thumb. So if you're living at home and you don't have any care needs, there's no real additional cost. If you need in-home caregivers, expect to pay $20 per hour. That's what you should get for a reputable care service. And you want to make sure they're licensed, they're bonded, the whole 9 yards. An independent living facility, expect to pay $2,500 to $3,000 a month. An assisted living facility, expect to spend between $4,000 and $4,500 a month. A memory care unit, expect to pay $5,000 to $6,000 a month. And a skilled nursing care facility expected to pay $8,000 to $10,000 a month. And as you can imagine, that's the scary number, because $8,000, $9,000, $10,000 a month is $100,000 a year. That's more than a lot of people make in an entire year, and that's to care for a whole nother person. And that's a very frightening prospect. And that's the biggest drainer of the wealth. And so what we want to look at is what benefits are available. So obviously you have your private funding, you have your own resources, you have family members. Then you can look to the VA. Obviously you'll be receiving some Social Security. And then the big one that everyone thinks about is TennCare, which is Tennessee's administration of the federal Medicaid program. And that always confuses people, so I like to emphasize Medicaid is equivalent to TennCare. Medicare is just the national health insurance we have for senior citizens. And so people will often get those confused. So misconceptions. The first thing about paying for this care, if you need a skilled nursing facility, is why I need to sell everything. There are usually only two things people know about TennCare, and it's kind of those two things that make themselves, they know just enough to be dangerous to themselves. One, I need to have less than $2,000, so I just need to spend everything. And two, the state's going to get my house no matter what I do. Neither one of those are exactly correct, because there are lots of steps that you can take following the rules of TennCare to comply with the rules and regulations and qualify in a much quicker manner. And that's the mistake people make, is they don't understand that TennCare is actually a very complex government program. And although there are some rules, like they do have that $2,000 limit, and they do have something called a state recovery, which after you've been on TennCare and you pass away, they will ask to be paid back with what's in your estate. But the good news is they can only recover from what's in your estate. And if the home is no longer in your estate, then they can't recover from it. There's also the ability to transfer a home to a disabled child. You can do an interspousal transfer. There are other steps that you can take. And then obviously one thing that we emphasize on, because everything, when you do it early, you're going to be in a much better position, is doing some good trust planning. So how do we want to frustrate estate recovery? I want to take the home and place it into an irrevocable trust. And what that does is it's a transfer of legal title from the home. Now, TennCare is going to penalize you for such a transfer. And what they're going to do is they have a penalty divisor, which is right around $5,500 a month, right around, just a rule of thumb, right around $60,000 a year. So if I transfer $60,000 worth of assets, and now I'm qualified for TennCare, financially speaking, they will look at it and say, yes, you meet the requirements. However, you made this transfer of wealth. And so we are going to not turn on TennCare benefits for 1 year while you are in what's called the penalty period. So not all penalties are bad. That's one thing. So when you hear the penalty period, don't think it's the worst thing in the world. And the second thing is they only penalize transfers of wealth out or within the last 5 years. And so if you place the home into an irrevocable trust and then you don't need skilled nursing care for 5 years, you have now frustrated estate recovery. The home is in the trust and you don't have anything to worry about losing the home, and it won't be considered a countable resource. It is a great planning tool for those that want to plan ahead. And what that's going to do is, because it's no longer in your name, nothing is in your name to recover against. And the beneficiaries of that trust are going to be your children or whoever you wanted your heirs to be, whoever you wanted to inherit. And what you're doing is you're kind of taking your estate plan, and I like to refer to it as turning it upside down a little bit. We all think kind of what that first slide at the very beginning, all I need is a will. I pass away, I have a will, the will says what happens, and my stuff goes away. Well, in this case, you're giving it kind of halfway away. It's kind of an incomplete gift into the trust. You haven't given it all the way to your heirs. but you have put it into the trust for safekeeping. And what that's doing is a benefit for you, and it's a benefit for your children. And now I'm going to fast forward because talking about the gifting, people will say, Chris, why do I need the trust? Why don't I just gift it straight to my children? Because we are trying to mitigate the risks to your estate. We're not trying to shift the risk that you have. If you take your home and gift it to your child, what you are doing is you're just taking your risks of losing the home via estate recovery and the possibility of TennCare, and now you're shifting that risk to your children. Well, your children typically are having much more active lives. They're out conducting business, they're driving around, they have all sorts of things. If they get into a bad car accident, heaven forbid they hit a school bus or something like that, they are going to get sued. If they get a divorce, and we all know what divorce rates are like, that is their asset. And it'll be something that will be attacked in a personal injury lawsuit. It will be gone after in a divorce settlement. It is no longer yours. It is your child's. And I've gone through this with a client who transferred a great deal number of properties to their child. And they were very upset to learn that that property was susceptible to those bad life events. And divorce is unfortunately not an uncommon thing. People get into accidents, people suffer bad financial events at work, and we're going through a pandemic right now, and they end up filing for bankruptcy. And all of those things place that property at risk, and we don't want to do that. And another thing people do is, well, I'll just put it so we all own it together. That's the worst possible decision, because when you do that, now you have everyone's risk all rolled up into one. So we not only have we not mitigated the risk, we didn't even shift the risk, we've compounded the risk. And that's a huge mistake. So straight up gifting is not a great plan. The other issue is you have tax consequences if you gift the property to your child. They're going to lose a step up in basis, which could be a very significant tax burden to them down the road. You haven't done them any favors.
Chris, that's probably one of the biggest mistakes that we see in our practice as tax practitioners is the client who comes into our office and says, oh, this year I deeded my house to my daughter or my son or both of them. And I usually get that really sick look on my face, and we start talking about, okay, maybe we need to talk to an attorney and see if we can undo this, or because as you were saying, the problem there is when you gift during your lifetime, you give the recipient your tax basis. And tax basis is that value that we use to measure gain or loss on the sale of a property. And typically that basis is what you paid for it. So let's say mom and dad paid for their home decades ago, paid $25,000 for a home. And I'm just pulling numbers out of the air. And now 50, 60 years later, that property is worth $250,000. Then if son or daughter who has now owns that property go to sell it, then they have a built-in tax gain on the sale of that property. Whereas if mom or dad had decided to sell it, if both of them are still living, they could have excluded up to $500,000 of gain on the sale of that home. Or if one of them is only one of the parents is living, then they could have excluded $250,000. So yeah, just deeding something over, or even just adding a child's name to a bank account can really mess things up as well, just in terms of planning. So yeah, that's a great point, and that's one that we see an awful lot.
Yep. And in fact, that's the next slide, is the impact of joint accounts. The same issue with joint accounts. If you're putting the child on there and the child has a negative event, whether it be a divorce, whether it be any of these things, you are making that account susceptible. And so you have to be exceedingly careful and cautious. Not to mention, it will, in the eyes of many benefits programs, it will look as if you're doing a gift. Hey, if you put them on there, well, the account is basically dividable between all the people on the account. And so you're going to get penalized for a gift where you really haven't made one. And it's frustrating. Now, you can cure gifts, but again, we don't want to be curing anything. We want to get it right the first time. Now, I'm going to up my clip just a little bit as I'm keeping an eye on time. The VA stuff, I want to talk about veterans benefits, the Department of Veterans Affairs. one of the key things I want to emphasize up front, when you're dealing with the Department of Veterans Affairs, another organization, part of our government that does great work, but they are very overwhelmed and they are underfunded for the mandate that they have been given. So they are notoriously behind on things, and having your, whatever your submission, whatever your claim is, done right the first time is vitally important to getting benefits turned on in a timely manner. And I put this information slide, and I know they're going to make these slides available via PDF, so I'm not going to belabor it. But what I just wanted to emphasize, when you look at this, the VA is the largest healthcare provider in the country, 1,200 medical treatment facilities. Long-term benefits, long-term liabilities of the Benefits Administration, $2.5 trillion and $60 billion for education. When you think about administering that amount of money and managing all of these programs, you can see how quickly overwhelmed they would become. The VA has essentially three arms: the Veterans Health Administration, which is the hospitals; Veterans Benefits Administration, which is your educational benefits, your non-service connected pension, your service connected pension; and then the National Cemetery, and that's what everyone thinks of with the burial benefits. If you want VA healthcare, go to Google, put in a VA Form 1010EZ, and it's a one-page form, and you fill it out, and they have 8 different priority groups. And if you're a veteran, you fill that in, and you will get assigned a priority group, and that'll tell you if you can get in and be seen at those facilities. I always tell people on the VHA side, it never hurts to ask. I know a lot of people who do it just for the prescriptions, because the prescriptions are obviously at a much better price than you would just going out through your regular civilian provider. Now, the pension, there are 2 types. I'm going to emphasize on the non-service connected pension. Touching the service connected really quickly, if you suffer an injury or any type of medical condition that happens in your service, related to your service, and will continue on the rest of your life, they will give you a rating and provide you some compensation for it. And they have, I mean, literally everything under the sun. They have a big book, and it notes what the percentage is for each thing. I'm not going to belabor it, but if you have any service-connected maladies, it's worth reaching out and getting rated and understanding what that is. There's no financial means test. It's considered you've earned it through whatever the medical issue is that you suffered in service. It's a lifelong condition. They are going to treat it as such and provide you compensation. The other side of the coin is the non-service connected pension. Generally for people who are 100% disabled or 65 years of age or older. And that's the one that we deal with almost exclusively. You're over 65, you're a veteran, and you meet the following service requirements. You've served 90 days on active duty, 1 day in a wartime period, and then you meet the financial means test. Now, the wartime periods there, they are rule of thumb 41, 46, 50 to 55, 64 to 75 unless you were actually in Vietnam, and then it's 61 to 75, and then 1990 through now. Now, again, if you think the VA's job's getting easier, think about those wartime periods. The longest one was Vietnam at 14, and those are the veterans we're seeing now. All the Vietnam era people are over 65, and they're really in the wheelhouse. Look at the Gulf War. The Gulf War has been open 30 years now. Imagine what the VA's unfunded liabilities are going to be down the road 20 or 30 years. It's almost incomprehensible, and it's probably something that Congress is going to have to address. So I said there's a financial means test. Very simple. Asset cap, 100 for this year. It goes up a little bit incrementally, but this year is $129,094. Your house is not a countable asset. Your car is not a countable asset. Remember the rule of thumb on your home, less than 2 acres. If you have a family farm, a much more complicated decision. Basically, you look at the home in 2 acres, and then you look at the value of the other land, and that will be considered a countable resource. Here are the pension rates. Again, not something I want to belabor. You'll have access to these slides, but that is what the monthly payment will be. And why people like this benefit is it is a cash payment into your bank account. So it can stretch, if you're a single veteran, $1,100 up to $1,900. A married veteran, you can get up to $2,200 and change. Even if you're a surviving spouse, you can get up to $1,200. It makes a really big difference month to month. And the example I use is, let's say I have $1,500 in Social Security and maybe $600 pension from a job. So I'm at around $2,100, and I'm a married veteran and I need aid and attendance. I need to be living in an assisted living facility. Well, that $2,200 will bring me up to around $4,300. Well, we remember from a few slides ago, what's an assisted living facility cost around here? $4,000 or $4,500. So it's kind of an income augmentation. Now, the key thing is your income, how they measure your income. I talked about your max resources, but they also look at your income. They have something called the IVAP, the income for VA purposes, the simplest math problem you'll ever do. And that is, what is your gross income? And then you subtract out your unreimbursed medical expenses. Well, if your gross income is that pension and that Social Security in $2,100, and your unreimbursed medical expenses are $4,000, $4,500, that you get a negative number. And if that IVAP is 0 or negative, you get the full amount of the pension. If that IVAP is $100 or $200 in the positive, you get what's called a partial pension, where it'll give you some of that dollar amount, but not the full amount. So unreimbursed medical expenses, when we do the planning, the goal is always, we're looking at the IVAP, we want it to be 0 or a negative number. And almost always that's just the way it is. If I have someone who's at an assisted living facility, in memory care, in a skilled nursing facility, almost inevitably, their unreimbursed medical expenses well outpace their income, their IVAT's negative. If we have in-home caregivers, then we need a personal caregiver agreement. We need a contract. We also need an attendant affidavit, which means that person who's providing the care actually signs an affidavit saying, I'm providing the care. It's just a fraud check for the VA. A child can be a caregiver. So if a child is, even if the child's living with mom and dad, you can have them be the caregiver and pay your child because they think that's appropriate. You cannot, however, pay your spouse. That's considered a spousely duty. So you cannot enter a caregiver agreement with your husband or your wife and say, well, they're providing my care. That's their job. So keep that in mind. Common concerns and questions. Married couples are treated as a single unit. And so just if the wife has income and the husband have income, it's going to be the total of income. If they both have assets, even if they keep their assets separate and apart just to the way they're living life. Now, you can have where they are living completely separate and apart. You can let the VA know that, hey, the spouse is not contributing whatsoever, and then ask the VA to treat the veteran as a single individual, and oftentimes they will do that. So that is a possibility if that is the circumstances on the ground. If you have a joint account, don't add. People used to use that. The VA used to have some very lax rules until October of 2018. And one way to get down income was to add a kid to an account. And then the joint account was kind of considered half the kids and half the parents. That is a terrible planning tool these days. The VA really tightened up on that. And if someone says, oh, that's a great way to do it, they're simply wrong and uninformed. The VA has an accreditation process. I am a VA accredited attorney. Tim and Barbara here are VA accredited attorneys. It is paramount that you have a VA accredited individual help you with your VA claim. The VA manual is it's as bad as the tax code, and you need someone who understands the rules and can apply them appropriately. I just had a lunch the other day on Tuesday with a friend of mine who I had helped with one of their parents through this maze. And then now they have an in-law, and they were dealing with a VSO, a veteran service officer, who's someone who should be trained in this. And even they were getting some very bad advice. It was very frustrating because it makes it hard about who you should trust, but you need to make sure they have that accreditation. With regards to divorces, the rule of thumb is divorce severs benefits. There are some exceptions to that. If the divorce was due to abuse or abandonment, the surviving spouse has a claim. And then there are some weird little rule carve-outs for some time frames about remarriages and whatnot. And I would just say consult with an attorney. It's too much minutia now to get into. So there's a little, so you get a little snapshot of some of these rules. I tried putting them on it. Enjoy reading them when you get the slides, because I'll tell you, I go back when I have a divorce or a remarriage issue, I go back to the statute every single time. It's that convoluted, and it's one of those things you cannot guess on. You got to get it right, and I pull the statute every time, read through it, see if my client gets through it. Why they did these carve outs, I still don't know. I imagine, you know, if someone knew a congressman, and I think that's always the way these carve outs come. Now, I talked to you about the VA making the rules tougher. They never had a look back period. The VA, you truly could just give stuff away up until 2018. And the VA realized that's not a good way to administer the program. A lot of people acted like the sky was falling. There's going to be a look back period. This is terrible. On the whole, they did a pretty good job of balancing the interests of the veterans and the veterans' family with keeping the program solvent. That's the same reason why TennCare has a 5-year look back period. If everybody who found out they needed skilled nursing care on Tuesday could give everything away on Wednesday, and then on Thursday turn out their pockets to the state and say, cover my health care, the system would collapse in a month. They can't have that. And so the VA implemented the same thing. It penalizes transfer only of covered assets. And I emphasize that because the home is not a covered asset. You can transfer your home and not receive any type of penalty. So there's a good opportunity for trust planning there. Also, they don't penalize transfers that wouldn't have affected eligibility. So if you only had $90,000 and you gave away 60, there's no penalty. Why? Because if you had the 90, it still wasn't over the $129,000 cap. So the 5-year, they have a 5-year cap on the penalty period. So 133,800 is kind of what triggers the 5-year, that would maximize the penalty. But remember this, if you get a max penalty in VA, someone has committed malpractice because there's only a 3-year look back clock. And if you're going to transfer an asset that would make a 5-year penalty, you would be wiser just to wait 3 years and apply, because then the transfer is not a reportable event according to their rules and regulations. Exceptions to the transfer penalty. If you can show that you were the victim of an unfair business practice or fraud, someone convinced you to buy an annuity that they said was VA compliant that wasn't, and spoiler alert, don't buy annuities for VA planning. They're not going to be compliant. If you can prove that, and the burden of proof is actually pretty high, you're probably going to have to show a report to the Better Business Bureau or possibly even a police report, and it's just exceedingly rare. You can transfer to a trust for a child, a special needs trust, who is incapable of self-support prior to age 18. So if someone has been disabled since a child, you can transfer to a trust for them. That's a great planning tool. And then I talked about already transfers that don't affect the net worth determination. You can always cure a gift. The VA will just want you to show it. They say evidence of the cure must be received by the VA not more than 90 days later after the notice of decision. So after they say, hey, we're penalizing you, you have 90 days to cure it if you so choose. Where people make mistakes, don't do multiple transfers in the 3-year look back period, because it'll reset the clock. And then what they'll do is they'll take the most recent transfer and say the clock started going that on everything you've transferred. Don't make that mistake. Homes greater than 2 acres, because people will hear, whoa, a home is exempt asset. I have a farm, that's my home, and they transfer the whole home. Well, the problem is if it's 100 acres, the 98 acres are going to be penalizable in that transfer. The transfer of the home is only if it's under the 2 acres, or if it's over, the additional acreage is unmarketable. So if you're on a 2.1 or 2.2 acre plot where they couldn't carve out that little section, that you're going to be fine on that. But you want to make sure you know what you're doing. Annuity-based planning, the VA does not like annuities, and that's really just keep that as a rule of thumb. And then poorly drafted trusts, where the grantor gets some right to income. For the VA, that's going to make all of the assets in the trust countable, and it defeats the purpose of doing the trust. Aid and attendance. There is a medical piece to the VA, and it's called aid and attendance. And so you get additional compensation if you need help with 2 activities or more of daily living. And so the form, when you take it to your healthcare provider, these are just the tips, and I'm going to hit them real quick. Make sure it's accurate and comprehensive. What did our English teachers tell us in high school? I can't read between the lines if there aren't lines to read between when they were grading your paper. There's lots of white space on this form. Tell your doctor, please fill it all in. Paint that word picture of my condition. I talked about it earlier with the ADLs. These are pass-fail events, and so the doctors need to be treating them as such. Ensure the doctor's handwriting is legible. Now, as an attorney, I don't have much room to, throw stones on that one, but I will say they also, if they can't read it, it's not doing any good. Make sure the limitations are front and center. What do they say in the news industry? Don't bury the lead. If you have something wrong with you, make sure it's easily found in the document. Incontinence is an issue no one likes to talk about. You need to make sure that's addressed. It's a very important ADL. And then have a conversation regarding the appropriateness of a fiduciary. There is a fiduciary question on there. There is a fiduciary process the VA has if they deem that you cannot take care of your own financial events. And what I always say is, if you have family members helping you and they do a good job and are trustworthy, it is appropriate to say, no, I don't need help. And then just note, I have family members helping me to avoid, it's just kind of a Byzantine process, and it's an additional layer that's just unnecessary. Filing claims, use a VA accredited attorney, be relentless, get it right the first time, plan early. I cannot emphasize enough. And so now's the time, not the time for do-it-yourself. With proper estate planning, I can't tell you the number of times I've seen people bring in wills, powers of attorney that they got off LegalZoom, and I'm not picking on LegalZoom or any of the other law forms kind of document providers out there on the internet. But remember, that is a cookie cutter approach to what needs to be very tailored planning. Everyone's situation is different. And when someone comes in and says, well, my neighbor down the street did X, and boy, that sounded like a good idea and it really worked for them, so I want to do X. You have to ask yourself, well, why did they do X? What is their family situation like? And that might have been a good fit for them, but you don't know all the underlying facts that drew whoever was doing their planning to that conclusion. Every one of us, just like our fingerprints are unique, our financial situations are unique, our familial dynamics are unique. They are all unique fingerprints, and they need to be evaluated. They need to be evaluated by a professional, be looked at, and your plan needs to be crafted to fit your unique needs and situation. And not to mention that many of these documents need to be executed with the appropriate formalities. A will, we need witnesses. We want those witnesses to sign an affidavit swearing that they were the witnesses. We need to make sure these things are notarized. All of these things are vitally, vitally important. And if these documents are not executed properly, they could fail at the time you need them most. What not to do. These are some tips, not always the right answer, but generally the right answer. Co-powers of attorney and co-trustees. Nothing legally problematic about it. But if I have 2 people as co-trustees and they disagree, they can't act because the trustees have to agree at that point. And so I always say I count a trust, or, if you have a will or the power of attorney, I liken it to, my nautical background from the Naval Academy. Every ship has one captain. And I want one person making the decisions, because I don't want these documents to fail simply because there's a disagreement to the parties. If you got 2 worthy people, feel lucky, because now you have a primary and a backup, and not everybody has that. And that's how I would lay that out. And if you want to treat children fairly, make one the trustee and the other the backup trustee, and then flip the roles. Make the other one the main power of attorney and the other one the backup, and kind of make everyone feel like they have a role. Almost anything is better than making them co. Don't download forms off the internet. I've hit avoid conservatorships. I've hit that. Don't give everything away to your kids. I call that the purposeful pauper. I just had a meeting this week with someone who said they were advised to do that and were really upset about it. And that's how they ended up with us. And I said, I promise you, I will not make you a purposeful pauper. And they were very appreciative of that. There are still people out there that'll give that recommendation. And it's neither wise nor necessary. These are your funds. You've worked a lifetime for these things. To just simply be told, well, you should just give it all away to your kids and then your kids can just give you money. That's not how it works. And that's not how it should ever work. Good estate planning can make sure that your assets are protected without just giving everything away. Don't attempt a VA application without a VA accredited attorney. And I'm going to leave you with this last little thing, this Chinese proverb: the best time to plant a tree was 20 years ago, but the next best time is today. And so remember that if you haven't done your estate plan, I've had people in their 80s come in and they sit down with me, and it's so funny. They sit down and chuckle and say, Chris, we think it's about time to get an estate plan. And I always laugh because they're not wrong. They're absolutely right. Yes, we waited. Yes, I wish they had been in 5, 10, 15 years ago, but it doesn't mean they shouldn't have come in today. And that is crucially important. It is never too late. And once you have it done, remember, one of the biggest kind of intangible things of a good estate plan is peace of mind. At the end of the day, when it's done right, when there is an event in the family, someone is hurt, incapacitated, someone passes away, we're not worried about, oh my goodness, have we done everything? You know, we're scrambling, shoot, we don't have a power of attorney, we need to get a conservatorship. No, we can focus on what's important: taking care of mom and dad, grieving for mom and dad, being there for each other. Why? Because the legal and financial piece is taken care of. And that is peace of mind, not only to you, but it's a gift to your children. So with that, I have talked a lot. I think I kept it just over an hour. So I think I'm going to open it up to questions. Steve?
Chris, I can tell you, I learned a lot this afternoon, and the whole area. We have a lot of veterans here in the Clarksville area, as well as, you know, in Nashville and around Middle Tennessee. And some of the things you touched on were very eye-opening for me. So I'm probably going to do a little bit more research. I may be sending you some emails and asking some questions.
Okay.
And that brings up a good point. If folks do have questions for you later on, how can they get in touch with you? What's the best way?
So our phone number is right there on the screen, the 615-824-2571. Call, set up a consult. I love meeting with clients. My two favorite things about my job are, one, sitting down with clients and potential clients and helping to solve their problems. And number two, this community outreach piece, because just getting the information out there, empowering people with information and knowledge, so they can look at their situation and go, oh, some people are going to evaluate it and say, I'm in a good spot. I've done all the stuff Chris has talked about. And if that just gives them peace of mind, that's fantastic. But for those that don't have all those things done, and now they kind of have like a direction to go, okay, I know what questions to ask. I need to get this stuff taken care of. My favorite things to do. And so I would just encourage them to reach out and know that I will love sitting down with them and going over everything.
Great, great. I know if I could leave one thing with our clients who are listening in this afternoon, and it would be, ask before you take action. You know, before you change the name on a bank account, before you change the name on a deed, before you change the structure of a business or the title to any kind of property. Ask questions before you do that, and it's really both legal and tax implications for both. So. That's probably the biggest mistake we see with clients is making those changes and asking questions later, and it can be very difficult and costly to undo those types of decisions if it was the wrong decision, and giving away property is usually a bad decision. So.
Yes. Almost always.
Do we have a question? All right.
Do you do meetings by Zoom since you're in Nashville?
Absolutely, we do. So we use RingCentral, which is essentially a Zoom-like platform on it. We can do virtual meetings. Over the last few months, due to the pandemic, because frankly, our client base is a little more susceptible to this than other people. And so we take that very, very seriously. We worked from our homes for a couple of months. Now we've moved into a new facility, which helps us really practice social distancing. We have a lot more square footage, so we can do in-person meetings and do them safely. We have a very strict regimen. There's a protocol, questions that are asked. We take temperatures. We have a contact tracing log. So the health and well-being of our clients is at the forefront. And so while I would say in-person meetings are perfectly fine, just due to distance and convenience, we absolutely do RingCentral meetings. We have it down to a science. We send out the client a link. You click right in. You can do it telephonically, or you can do it like this with a web camera base. And what's even nicer is the governor has signed a couple executive orders. He signed one back, I believe it was April was the first one. It's been extended twice now. The current one will expire on midnight on the 28th, but it allows us to actually conduct signings and execution of the documents over this platform. So we can draft the documents, email them to you, or snail mail them if you don't have a printer. You can have the documents on that side of the camera. You identify yourself to us and show the proper credentials, and then we actually physically watch you sign. You get a self-addressed stamped envelope to return to us. You return the documents. We put the notarial stamps and the witness signatures where they need to be, and you've executed an estate plan, and you've never set foot in our office. And we've done more of those than I can count now, just due to the nature of the way things have been the last couple months. Very adept at it, and very happy to accommodate whoever needs the accommodating.
Okay. Is there another question?
Is adding a contingent beneficiary on accounts considered making a gift when you have a durable power of attorney for your parents?
Making a contingent beneficiary on a beneficiary designation form is not making a gift. And I'm sorry, I started to answer. I was jumping on it so quick. What was the second part?
Let's see. When you have the durable power of attorney for your parents?
Okay, that's good. You can make a beneficiary designation with the durable power of attorney if it provides that authority, and the odds are it does. If it's a general durable power of attorney and has all the kind of regular authority that you would expect one to have, then you should be just fine executing that if it were appropriate, remembering your fiduciary obligations to do what's in their best interest.
Okay. Any other questions from our viewers? All right. If not, then Chris, I just want to say thank you once again. What a great presentation this afternoon. Lots of great information. You have me thinking about some things. So I have some action I think I need to take care of, and I'm sure a lot of our listeners do as well. So once again, give them your email just one more time.
Yeah, my email is cjohnson, JOHNSON, at tn-elderlaw.com. So cjohnson@tn-elderlaw.com, and my phone number, you see it on there, 615-824-2571. Steve, deeply appreciative of the invite. Always happy to be out helping the community. Honored that you guys are paired up with us. It's great to be out here doing this.
Thank you. And we appreciate you taking the time out of your schedule to speak to our clients this afternoon. And so all of you who are listening, like as I said earlier, take a look at our website. It's constantly updated for other webinars on different topics, and stay in touch with us so you can take advantage of more educational opportunities like this. Thank you, everyone. Have a good afternoon.
Thank you.